Number 130 and 131. Counsel, would you like any rebuttal time?
Yes, Your Honor. We'd like 3 minutes of rebuttal time.
3 minutes, sure. Go ahead.
And in accordance with the suggestion of your Chief Clerk, we've attempted to divide up the argument. I'm going to cover the express preemption issues as well as the many reasons why we don't think this Court should follow the mine land reclamation law, and Mr. Kurkowski is going to cover the implied preemption issues.
Okay.
So, Your Honor, may it please the Court, we think that this is really a very simple, straightforward case, that the courts below have really misinterpreted what is a very clear preemption clause and a very clear statute.
What does that clear preemption clause say?
What it says specifically, Your Honor, is that the provisions of this article shall supersede all local laws and ordinances relating to the regulation of the oil and gas and solution mining industries, but shall not supersede local government jurisdiction over local roads or the rights of local governments under the real property.
So what happened here? What was the town trying to do?
What happened here?
That has to be superseded.
Yeah. What happened here, Your Honor, this is a very unique case. In both of these towns, they enacted complete bans on oil and gas activity.
Well, why isn't there right to do that?
Well, because, Your Honor, we have a situation where we have express preemption by the provision that
as to zoning type regulations.
Absolutely.
You have express preemption.
So how is it express? Is it you saying the word regulation encompasses zoning?
It does, Your Honor. And first of all, you have to look at the entire statutory scheme and the entire statute, the entire preemption.
We have to look at plain language.
Exactly. And
initially,
it says,
correct?
It says all local laws and ordinances relating to the regulation. And what the lower courts have done and what our adversaries have done is they've focused only on that snippet relating to regulation, and then they've tried to analogize this to the mining cases with the Frew Run case and its progeny.
So you say this is for express preemption, the legislature has known how to do it.
Correct.
In hazardous waste siting, in community residences for mental health folks. They've specifically indicated zoning.
Your Honor, you are correct.
It's kind of curious that if zoning was encompassed
you are
there,
correct
that there wasn't a particular reference to it.
You are correct that there are times when the legislature has expressly referenced zoning, as it did in the mine law reclamation law, where it carved out zoning as an exception to the preemption.
Why couldn't they have done it here?
They could have, Your Honor, but, you know, this is not a test as to whether or not they should have used a particular phrase.
No, but you're talking about express preemption.
We're talking about something that occurred in 1981, before the Frew Run decision. Almost every one of the zoning ordinances that Judge Graffio referenced and was referenced in the briefs for our opposition came up after Frew Run came down, and the legislature got it. Okay, if you want to preempt zoning, you say zoning. But at the time in 1981, when this law was enacted,
why isn't Frew Run very directly relevant to this case?
Well, Your Honor, first of all, there are fundamental differences between the oil and gas solution mining law and the mine land reclamation law.
You don't think that the essential theory of the decision is the same?
It's absolutely not. Because
why not?
If you look at the supersession clause at issue there, and again, I have to quote it, it talks about superseding all local laws relating to the extractive mining industry. It's notable, they don't mention regulation there. They just say relating to the extractive mining industry. But then they go on to open up the barn door for zoning, and they say, but nothing in this article shall be construed to prevent any local government from enacting local zoning ordinances or other local laws which impose stricter mine land reclamation standards or requirements.
And it's your argument that if they wanted to do that in this industry, they would have done the same thing. They would have put that wording in saying nothing will, and absent that language, then zoning is superseded as well.
That's correct, Judge Piggott. You have to look at you go back to the statute. It says all local laws and ordinances. It talks about jurisdiction being limited to two discrete matters, okay, which one is road control and two is real property taxation.
Counsel, you don't think that you have to look at the term regulating at all?
I think if you look at the term regulating, and if you go to the town law, Section 261, which is the enabling law for local zoning, That says that the towns are authorized to regulate the location of buildings and land uses. Okay? And since the preemption clause here talks about relating to the regulation of the oil and gas industry, I think the analysis stops there.
Well, but for Fru Run, wouldn't you have a very simple argument saying if you're prohibiting something, you're regulating it?
That's exactly right, Your Honor. And
but isn't Fru Run and maybe even more Granite Asphalt? Don't they give you a problem?
Well, let's talk about both of those cases, because if you go back and read Fru Run carefully, the court explained its reasoning. It said that there are two legislative aims in this statute. So, in other words, it was a hybrid preemption clause. On one hand, they took it away and said you can't do anything relating to the mining industry. And on the other hand, they gave it. They said, but you can do whatever you want through zoning relative to reclamation. They went on to analyze how the mining law has two essential components: regulating the operational aspects of the industry and regulating reclamation. Reclamation governs the ultimate land use. Open sand and gravel mines have sometimes occupy hundreds of acres.
Tell us why oil and gas is different.
Well, oil and gas is fundamentally different because you start with the purposes to prevent waste, to promote the ultimate recovery of the resource, and to protect the correlative rights.
Are you saying really that with oil and gas, to regulate it, you've got to regulate location?
Absolutely, Your Honor. And if you understand the way the oil and gas statute is created, integral to the statute is the concept of spacing. All right, and what happens with well spacing is if you have a pool of oil and gas, no matter whether it's 10 acres or thousands of acres, you have to lay out spacing units so that you don't strand the resource and create waste. And in practice, the way this happens is they set up these rectangular.
What can the municipality do in relation to fracking, or, in this particular kind of nothing? They have no say in what happens. Their elected officials have no say in what happens in that municipality because it's all superseded. There's nothing they can do, anything to do with oil and gas.
We would not go that far, Your Honor.
So what can they do? What's the answer to my question?
First of all, they can regulate local roads, and that's a big issue with high volume.
They can regulate local roads. How so? Relating to?
Well, they can regulate. They can post limits on weight as long as those apply even-handedly to all the industries. They can in most cases
the weight that can be on the road.
Yeah, and the bridges, and they can post roads to be off limits. They can help them dictate routes. They can talk about timing of when deliveries should be made to these sites.
Yeah, but in essence, those are really on the fringes in terms of this whole issue. Basically, you're saying that they don't have really any say when it comes to oil and gas, other than these tangential. On the roads.
Well, yes, you're saying zoning. They can't zone it out.
They can't zone. That's correct, Judge Reed. And they were specifically granted limited jurisdiction.
Isn't zoning fundamental to the power of local municipalities?
Your Honor, I think.
Can that just be taken away so easily and without expressly saying that you're taking it away?
We believe it can. We think the Wombat Realty case and the Albany Area Builders Association case say as long as it's a statute of statewide importance, the state has the right to preempt municipalities from a given subject matter.
In light of Fru Run, how do we know that this is, I guess you would say that this preempts where to drill as opposed to how to drill? Is there anything in the legislative history that tells us that this is not just a how-to drill statute?
You go back and you look at the oil and gas compact, which talks about requiring spacing units. You look at the oil and gas law, which talks about spacing.
So you're saying there's location right in the statute?
It's right in the statute, and it's been there since 1963, and it was in the original Oil and Gas Compact Commission from 1935 that we adopted in 1941. That's in the statutes, ECL Article 23, Title 21, and it expressly says you have to space this to prevent waste.
Would this be a different case if there had been a long-standing zoning regulation that said this area is residential only, no industrial use? Would that be preempted?
We don't think it is, Your Honor. We think the DEC has the authority to regulate not only spacing.
You don't think it's different, or you don't think it's preempted?
I think it is preempted, even if it's been even if it's been long-standing. The DEC, in addition to the
so even existing zoning laws
Absolutely, Your Honor.
preempted.
Yeah, because most of these
Not
towns.
something that a town, because they think there's going to be some contract signed, decide to pass a new zoning restriction.
And let me just explain why, Judge Graffio. Once you go through the requirements for setting up spacing units in a wellbore, and you get DEC to say that that looks good from a geologic standpoint, you still have to deal with all of the environmental restrictions and safeguards that the DEC imposes through the State Environmental Quality Review Act, and that they're agonizing over under the Supplemental Generic Environmental Impact Statement, which looks at setbacks from houses, schools, hospitals. It looks at watersheds. It looks at wetlands to make sure that you've picked a good location. Now, maybe
it's pretty drastic, though, to change long-time residential zoning restrictions. I mean, one would think that the legislature would be a little more explicit if that's what they intended to do.
Well, I think all means all, Judge Graffio, all local laws and local ordinances, and I don't think they have to, they don't have to say it. They didn't put it in the exception. If they wanted to exempt zoning, they should have put it in.
Well, I'm sorry. If we disagree with you that regulation means something different from what you're suggesting it means in this particular case, I take it, though, your argument right now, based on your responses to Judge Graffio, is if we hold against you, the State certainly could then pass a very express statute that makes very clear that they're preempting.
Absolutely, and what will happen in the New York legislative process regarding hydraulic fracturing, I think, is beyond any of us to predict.
Yeah, but that's up to them, isn't it?
But what's the issue?
Counsel, that's up to them, isn't it?
It is up to them, Your Honor, but what's up to you, as the court that agreed to hear this case, is a very clear issue of express preemption.
You think they've done it already?
We think they've done it already.
Okay.
We did it in 63.
Okay. You'll have your rebuttal. Let's hear from your colleague.
Good afternoon. May it please the Court. My name is Scott Kurkowski. I represent the appellant in this matter, the Middlefield matter, Jennifer Huntington. Jennifer Huntington is a dairy farmer in the town of Middlefield. She leased her property for purposes of developing her mineral.
So where's the implied preemption?
Your Honor, I want to just
where does it come from?
I want to make clear that we've been talking a lot about hydraulic fracturing. Jennifer Huntington was not going to hydraulically fracture her property. Her company was here to explore and develop her minerals by conventional means, the same means that we've been drilling wells with in New York State for over 100 years.
Where is their implied preemption?
The implied preemption comes, Your Honor, from different sources. It comes from a conflict. It comes from the fact that there's field preemption. And it comes from the fact that
Do you want any rebuttal time?
A minute and a half, Your Honor.
A minute and a half. Go ahead. I'm sorry. Go ahead.
So it comes from those areas because there are direct conflicts with respect to what's happened locally and what the state interests are. And the state interests are paramount. You asked earlier what's the important difference between this case and Fru 1. This is an energy case. This is dramatic.
What are the municipalities' interests? What interests do they have in this issue?
Well, what makes this an implied case, Your Honor, is that the DEC, through the Environmental Conservation Law and of this complex, comprehensive statutory scheme, has supplanted the rights of the
preempted the field?
They completely preempted the field, Your Honor. And if you take a look at that.
Even as something as basic as zoning?
Even
to a municipality?
But when you look at this statutory scheme, we have a specific tax provision that provides taxes to a municipality. We have a specific compulsory integration provision that happens without regard to zoning.
And you agree with your adversary, even with pre-existing zoning?
Well, with compulsory integration, we have to figure out what the pool is, what the unit is. And the reason is that
explain what compulsory integration is. You mean you can tell people where they can drill and where they can't?
Well, the concept in New York is that we need to be able to fully develop the resource, right? And pursuant to the policy of Article 23, we need to have an ultimate recovery of oil and gas. We need to protect the correlative rights of the landowners. In this case, my client's correlative right is her ability.
Let me ask a simpler question. If I am I'm in the oil business and I want to drill a well, and I have compulsory integration, that means the state is telling me where I can drill and where I can't?
That's how comprehensive this statutory scheme is. Yes, without regard to zoning, and that is because oil and gas pools do not follow municipal boundaries.
Your point is, if the state's going to tell you that, then it might be a problem if every locality can say no drilling here.
Of course, because if it turns out that I want to drill in a town that's immediately adjacent to Middlefield, but I now have this potential issue, then what's going to happen with my compulsory
You're saying it's unworkable if every town, every municipality can ban it or can whatever. It becomes an unworkable kind of patchwork thing.
It becomes a conflict, and therein lies the implied preemption, Your Honor.
Do we
because
know
of that conflict
do
that
we
happens.
know that there's no municipalities that want this, that have a supply?
Well, what we know is that there right now are 70 municipalities in the state of New York who have banned oil and gas drilling. So not only has the town of Middlefield taken the correlative rights of my client's right in the formation underlying her property. There is that right that is in Article 23-301.
Perhaps there's a suggestion that
but not
perhaps there's a suggestion that the population of New York is not so enamored of hydrofracking.
If you take a poll, it's interesting. But are we going to let 932 towns decide the energy policy of New York State?
What about the legislature deciding the energy policy of New York State if they're not clear on what they're doing now?
They certainly could have, right? They could have come in and said, look, we're going to come.
Well, why not let them come in now? Why isn't that a good thing to let the elected representatives of the people determine that again, unless it's already been determined?
The legislature, after you determine this case, can fully look at it, amend, like they did make that adjustment in the Prue-Run and Gurnett case for the mining law.
But I think you'd agree with your colleague that it's not so easy to get action in one direction or another. That's why we have this case, right?
We have this case.
If the legislature was going to tomorrow express their will in a definitive way, we probably wouldn't need focus in on what the scheme is exactly now, right?
I don't know if we have this case without the Prue-Run. No court in the country has looked at their mining law to determine their energy law. That's what has somewhat complicated this case.
So mining is so different from oil and gas that...
Your Honor, there's never been a sand and gravel crisis in this country. But we have lived through an energy crisis. And it is important.
Do you think even without Prue-Run, these other 70 communities would not have adopted those zoning restrictions?
No, those 70 communities came in. They thought they understood it. They thought that they might actually have the expertise that our DEC has. Doesn't make sense. But for some reason or another, they've decided, this makes us nervous, we're going to ban it.
So now, we're not actually deciding this case for just these two municipalities. There's going to be implications for the other 70?
That's the problem, right? Because not only has this town taken away the correlative rights. Yes, because they've taken away the correlative rights of my client, Jennifer Huntington. They've also taken away the correlative rights of thousands of landowners throughout the state.
But the law does say that the rights of the rest of the community has to be taken into consideration, does it not?
It does. But you know what?
So why does your client's rights trump all the other rights of everyone else in that community?
Your Honor, they don't. They are taken collectively, and they are viewed by the DEC. And this is where the appellate division did not get it right in its decision. They focused on one part of the policy statement that said that we have to focus on the general public. But that policy statement also says that we have to be concerned about the correlative rights. And they completely ignored the correlative rights. Take a look at the Supreme Court's decision in Voss, and that explains it perfectly. In fact, in Voss, they really relied upon the fact that the correlative rights issue, all paired with the fact that the state has this superseding interest in energy, that really is what made that determination.
Yeah, let me ask you, what
Yes,
thank you. What, if any, significance does the moratorium have if there's such a concern about the energy crisis?
Well, it goes towards, right, this overriding procedural policy that we're going through in the state, right? The suggestion that the towns don't have any say in this, well, what's going on is now we have a state that's been at this for 6 years on an SGIS, prepared a GEIS in 1992, and with respect to health impacts, there will not be an SGIS until our Department of Health decides on it. That's what's going on at the state level. That's where we have this comprehensive plan that is looking at these local interests, and these communities are saying, well, we don't have a say, but the state is saying, in order for us to do this. That's where this is decided.
That's where this is going to be decided, not in the local municipalities.
It has to be, Your Honor. It has to be because the
experts.
For
some kind of coherent approach?
We will not have a uniform state approach to energy if we allow 932 towns in the state of New York to decide.
So you're saying that's how it's different from FRU, or why it's not controlled by FRU, because FRU just involved an entirely different field, it was just mining?
Well, first, mining is one, right? The state interest is not the same. Right? The state will survive whether or not we have sand and gravel.
I'm having a hard time getting around FRU, so I'm asking you how would I distinguish it? Why isn't this just controlled by FRU?
Take a look at the jurisdictional issues as well. The jurisdiction statement in the oil and gas law says that the towns are preempted from having any jurisdiction over everything except roads and taxes.
You say the differences in the language or some material between the superseding clauses and the two?
Of course, it goes a lot farther than FRU does in the mining statute. That we are preempting you so that you have no power to regulate and have no jurisdiction over anything, except we're going to delineate two exceptions. And that's it. All but two. And otherwise, we have jurisdiction over everything.
You know what we did, what was done in the cell phone tower issue?
I know that the towns really have no say with respect to cell towers because it's an important national interest that we move forward with that.
But wasn't it spelled out rather specifically in the legislation that they could not oppose a cell tower in a given area?
Sure.
For that reason, because
it happens there. It happens with pipelines. It happens in the FERC. Right? If FERC wants to put in a pipeline, then the community cannot do that.
Why wasn't it clearer here?
It sure would have been a lot easier, Your Honor. But I can tell you, and we had introduced this in some of our motions.
And why shouldn't it be a lot clearer if it's a matter of, as you say, great policy concern to our state and to our country?
When we look at the plain language of the law, how is all and plus jurisdiction over everything except two things, how is that not clear? It is clear. I wish they would have gone further and said and zoning, but you know what? The fact that they didn't and the fact that they did do it in the mining law, that means something too.
But it's which category of all, right? Which of those laws? Right? They're making an argument that laws that deal with regulation may or may not be encompassed. That there's something already that somehow separates the all from every law and a subcategory of laws. That's their argument. Why doesn't that make sense, based on FRU, based on these other cases?
The regulation issue, Your Honor, take a look at what Black's Law Dictionary says, because regulation is really reviewing not just the procedures as the lower court did. It really is far broader than that, and it should be looked at in those terms.
Counsel, did I hear you correctly? Did you say that the regulation and supersession provision of the regulation in FRU run was narrower in scope than this one?
Well,
or is it broader?
I don't have an issue with the way that FRU run was interpreted, because I don't think that the state interest is the same with respect to sand and gravel. State interest in energy is gigantic. Just to give you an example, right, the city of Dunkirk has a power plant, a coal-fired power plant. And just this past December, the governor went to Dunkirk and said, we are going to convert this power plant from coal to natural gas. It will help our environment. It will help our economy. We will move forward in an important state interest. And in March of this year, the city of Dunkirk passed a ban on all hydraulic fracturing activities and oil and gas activities. Now, to the extent that that ban will impact the governor's decision to move forward with this power plant, that is a conflict that cannot exist. We cannot have the towns coming in and taking over on this issue.
Thanks, Counsel.
Thank you.
Counsel.
May it please the Court, my name is Deborah Goldberg of Earth Justice, representing respondents Town of Dryden and its town board.
Counsel, what is unclear about the preemption here? Why is this not express preemption?
Your Honor, the legislature knows how to do express preemption when it wants to do so. It mentions
but look at the plain language. What is it that gives you pause in the language that's there that to think that every county or every town can go and make its own ban or whatever it is?
What the language says is that it supersedes laws that relate to the regulation of the oil, gas, and solution mining industries. So if it were something that addressed the oil, gas, and solution mining industries per se, as such, it might very well be preempted. But what we have
what could be more expressed than a ban on doing it? How could it not affect oil and gas?
This Court has recognized not only in the FRU run line of cases that there's a distinction between regulation of a business and regulation of land use. What we have here is regulation of an industry.
Does that distinction really work in this industry when you're talking about regulating oil and gas drilling? Don't you have to, isn't that in itself regulation of land use?
Your Honor, there are locational requirements in the mine land reclamation law. There are locational requirements in the alcohol and beverage control law. Nevertheless,
isn't location really more basic, though, to oil and gas regulation?
No, Your Honor. The units that define where the drilling is done are defined entirely by the industry. The industry goes in, proposes it to DEC. DEC then accepts or declines it based on interest. So that they can choose their units so that they don't overlap with towns that ban it. They can set those limits. They don't have to paint themselves into a corner.
It certainly would have been easy for the legislature to put zoning in along with roads.
Absolutely, Your Honor.
I mean, it seems that would have been pretty basic. And they were certainly aware of zoning. Every single municipality has a zoning code.
Absolutely, Your Honor. Under their theory, absolutely every local law.
Why is it missing in the exceptions?
Because what was presented to them at the time, as you can see from the legislative history, was a concern about the ability to regulate the vehicles on the roads in the town and on the fees and other taxes that the towns were imposing because they were being forced to enforce this law in the absence of funding.
So if the legislature was aware of those problems, why weren't they aware of the other local considerations?
They weren't raised at the time. At the time, Oklahoma allowed bans, Texas allowed bans. I'm sorry.
I apologize for interrupting you, but how do you square the fact that the Environmental Conservation Law with respect to mining says nothing in this title shall be construed to prevent any local government from enacting local zoning ordinances or other local laws which impose stricter mined land reclamation standards or requirements than those found herein?
So
with the oil and gas one, which does not make that specific exception.
Your Honor, the mine land reclamation law allowed zoning only with respect to higher standards of reclamation, and what this court determined.
What I'm saying is that this law says zoning is excluded. Mining.
No,
zoning,
Your Honor. The mine land reclamation law says zoning with respect to reclamation.
You want me to read it again?
If you read the provision, it says it does not exclude zoning for higher standards for reclamation. It does not say it does not exclude, it excludes zoning completely. It has one very narrow type of zoning that's permitted.
Right, okay.
And this court nevertheless allowed them to zone it out completely.
Right, but they said that in the mining law. They don't say that in the oil and gas law. And I'm wondering if you have a reason why they were conscious of zoning in mining, but were not conscious of zoning in oil.
Zoning was not an issue in the oil, gas, and solution mining law because in Texas, Oklahoma, many other states, there were already bans.
Now you're reading I suggest to you that you may be reading the minds of the legislators, and they may be saying, we're not going to think about zoning because Oklahoma did something. I'm suggesting that maybe the legislature knew what it was doing because they wrote it in one law and didn't write it in another. Now, why would your argument that they were thinking about Oklahoma, I'm almost done, be stronger than my argument that they wrote two laws and one of them they considered zoning and the other they didn't?
If you follow your argument to its logical conclusion, then every single law of general applicability that's not mentioned in the exclusions is preempted. That means the truck driver can drive his truck into town with his radio blaring down the wrong way down the one-way street.
No. You can take anything to absurdity, and I understand your point, but I bet you have local constabulary, and I think you have people who will enforce vehicle and traffic laws and things like that.
Yes,
you can make bad arguments about all of that. Mr. Gutarski makes the point that you've got landowners who want oil and gas, and they're saying there's nothing in this law that says I can't do that, and the town now says I can't. But there's nothing in the laws. I can't, I can do my mining because they specifically said, that there could be zoning there and the town hasn't zoned, but there's nothing over here.
The mine land reclamation law does not say that zoning is excluded. The mine land reclamation law says higher standards are permitted under local law. What this court found was that there's a fundamental distinction looking at the initial enacting clause between regulating an industry and regulating land use. And even though the land mentioned zoning with respect to higher standards, it did not preempt zoning altogether.
Counsel, but even if let's say we accept your argument on express, does it make any sense on implied preemption that every different town can ban it, do what they want? Is that gonna work in terms of a statewide policy that exists for this industry?
There's two things to say. First of all,
doesn't that implied? Isn't that a harder argument for you to meet than the express?
No, Your Honor.
Why not?
Because, first of all, you don't need to reach the implied preemption argument at all because you have an express preemption clause here. And if you determine that there's no clear expression of intent to preempt in the express preemption clause, you can't turn around and say, but we're going to impute it to them anyways under implied
Well,
preemption.
I think that the Chief may be getting at a more basic point. It does say quite a few places in these statutes we want to foster and grow and may have a vibrant energy industry in this state. The question is, how are you supposed to do that if any town can prohibit it that wants to?
Precisely the way that Texas does it, and Oklahoma does it, and California does it, and Illinois does it, where all of the localities have exactly the right that we're talking about here, and the industry is thriving. This industry figures out what the lay of the land is, and it manages to accommodate itself and do very well.
That sounds like we should be stepping into the void that the legislature hasn't addressed.
No, Your Honor, the
Apparently
legislature...
there's an impasse with them trying to pass statewide clarification here as to whether it's preempted or not preempted. So we have to deal with the language of the statute.
Absolutely, Your Honor. The language of the statute is very clear. It stands in huge contrast to what you see in the hazardous waste law or in the gaming law, where there's explicit mention of zoning. It is silent. And under the principles of law in this state, when a law is silent as to land use or zoning, you cannot impute to the legislature the intention to create.
What do you think the legislature is trying to achieve with this statute about gas and oil? What's the purpose behind it?
The purpose of it is to ensure that as to the technical operations and activities and processes of this industry, you don't have the locality stepping in and setting up inconsistent regulatory provisions. And the towns in this case understand that that is the prerogative of the state. They are not trying to regulate the technicality.
So you don't think that individual municipalities, let's say there are loads of them, who want to put in bans would be inconsistent with the policy of the state?
Absolutely not, Your Honor.
What about the issue of waste? In reading the statute, I thought to a large extent what the legislature was trying to do was to prevent wasteful use of our natural resources.
Yes, Your Honor.
And over-extraction.
The oil, gas, and solution mining law does not direct DEC to promote. The promotion of this industry is in the energy law. If you look at the 6 policies of the energy law, 5 of them talk about conservation, husbanding resources. That's what these towns are doing. Waste is not kicked in. It's physical waste. It does not kick in until there's actual development. If you look closely at the amicus brief, for example, submitted by the Community Environmental Defense Council, that goes at great length into the history of that terminology.
Isn't the spacing of wells a very basic part of avoiding waste?
Yes, Your Honor. In conventional drilling, that is the case. In the type of drilling that we're facing today, the spacing is not a matter of producing waste.
Assuming you're right, presumably the legislature that passed this law was thinking about conventional drilling.
It was thinking about conventional drilling, Your Honor. But as explained before, and as the courts below have found, these spacing units are created by the industry. They can follow the municipal lines should they decide to do so. And secondly, what they do not explain to you is that even if the spacing unit overlaps between one jurisdiction that does permit it and another jurisdiction does not, it is possible with lateral drilling these days for the companies to develop the resources even underneath the towns.
So is anybody...
Are you saying you can regulate that?
Pardon?
Are you saying you can regulate that?
The towns are regulated in the surface uses. This is a land use rule. They are not attempting to regulate the subsurface drilling.
Counsel, was anybody thinking about hydrofracking when this was put into place? And is that part of the problem here?
Your Honor, we sort of can't have it both ways. We can't talk about what the SGS is going to do for
What's the answer? Was anybody thinking about hydrofracking?
No, Your Honor. In 1981, hydrofracking was not something that was...
How does that play into our looking at express or implied preemption if nobody even contemplated at that time
we do not rely on the idea that there's interest in hydraulic fracturing and horizontal drilling today in making our case. What we rely on is the principle that there has to be a clear expression of intent here. And when a law is silent, then this Court must find that there is an ambiguity at best as to the intent of the legislature, and when there is an ambiguity as to the intent of the legislature, it should find that there's no intention to preempt.
And does it matter, well, they said, what if everybody decided they're going to ban hydro? If each of the towns and villages, would that create any problem?
You know, that is plainly not the situation right now.
Let's say hypothetically it was. What's the consequence of that?
Then the legislature needs to revisit its law and determine whether or not it's important to promote this industry at the expense of everything else.
Why should we not think that they were worried about that sort of thing when they visited it the first time? That is, they passed a law that said, thou shalt not regulate. To the simple mind, doesn't that mean thou shalt not prohibit?
Your Honor, what the localities were doing at that time was attempting to regulate the industry. They were hiring their own petroleum engineers. They were stepping into the breach because DEC did not have the funding to do the actual regulation and to protect them from that.
This is in 1981?
Pardon?
You're talking about 1981?
Yes, Your Honor. At that time, in New York, they were not zoning out. They were in Tulsa, Oklahoma, but they weren't in New York. So that wasn't the issue that was presented to the legislature.
There's something, and this is not a rhetorical question, is there something so fundamental about zoning that this statute couldn't mean to take away the municipality's right to zone without expressly saying that they're going to do so? What's unique about zoning?
Your Honor, the legislature can take away the right to zone, unquestionably, and it has done so in some cases, as we have seen.
Yes.
But when it does so, it puts in place substitute protections for the interests that are typically protected by zoning. It doesn't leave the municipalities entirely at the mercy of the industry. It makes sure that there is a participatory process. It looks at the concentration of the industry. It looks at neighboring uses. None of that is present here. So in this case, there's no reason to believe that to impute to the legislature the idea that this industry would get the extreme and unprecedented right that no other industry has ever received in the state of New York, simply because we want to foster the development of oil and gas industry. We're not promoting it at all costs.
I'll ask you then, put aside for one moment, although that, of course, is the issue in the case, the rights of the localities to do this through zoning. If the landowners in a locality just simply did not want to permit this, could the state demand that they allow the industry to come in and hydrofrack?
No, Your Honor. I mean, if it were true that, oil and gas policy means that the industry gets to go wherever it chooses to be, it wouldn't have to lease the land. It certainly has to lease the land. If the landowner does not want a well on their property, they don't have to have a well on their property.
Let me ask you another question. If we hold against you and decide that indeed the bans are prohibited, there's preemption, is there anything that would prevent the state, foreclose the state legislature from then deciding that, no, we actually meant for the towns to decide on their own whether or not to permit this industry in their local boards?
Yeah, this is a question of statutory interpretation. If the
I
court,
guess the legislature could do, depending on what we do, they could disagree with us, whatever we want to do, right?
Absolutely, Your Honor.
I want to follow up just on one of your responses to Judge Piggott, if I understood it. Are you saying that this is only surface regulation?
Yes,
So,
Your Honor.
for example, if my farm is on the border between a town that permits and a town that doesn't, and I lease my land, it can go underground and drill horizontally into the town that doesn't?
Under the town, yes, Your Honor. Both of the towns have recognized that that is permissible under their zoning laws.
Okay.
Sorry.
Go ahead.
Let me follow up on Judge Reed's question.
Judge Smith and Abdul Salam. Go ahead.
You say you're saying they can do it because the towns let them, or they can do it because the towns are preempted from stopping it?
They can do it because the land use law doesn't address it. The land use law addresses typical use of the property.
So suppose you pass another one tomorrow that says we got another zoning regulation, no horizontal drilling. Is that valid?
No horizontal drilling? No, Your Honor. That would be a regulation of the industry. That addresses the technical process.
So this is land use, but this is regulation of the industry.
When it's prohibited from the surface of the land within the town, That is a land use regulation.
The drilling in from the side isn't use of the land?
No, Your Honor, it's coming from another town where it's permitted.
Okay. Judge Abdul-Salam.
Yeah, it was just, that may segue right into the question about the compulsory integration
Yes.
that was discussed by your adversary. Would that cover, if another town next to the town that banned it allowed it, would that cover the compulsory integration problem that your adversary mentioned?
Yes, Your Honor. If there were landowners in the town without a ban that wanted it and some that didn't want it, it would be possible to compulsorily integrate a unit of people who did not want the surface of their land used. What compulsory integration does is it helps the industry build a unit where it can drill. And if people do, and you can force 40% of the leases into that unit, it still protects their surface, but it allows the resource underneath their land to be developed.
Okay, counsel. Let's hear from your colleague. Counselor?
Good afternoon. John Henry Whiteman, Osman and Hanna on behalf of the town of Middlefield. I would submit that the issue in front of the court today is whether there's a difference between a local law relating to an industry, which was the language of the mine land reclamation law at issue in Frew Run, and a local law relating to the regulation of an industry. I would submit that there's no functional difference between those two statutory terms, and if there is, it's a difference that favors the town's position here because it imposes an additional limitation on the preemption provisions of the statute. So what the appellants argue here, frankly, their best arguments, their best statutory construction argument is that the oil and gas law contains two reservations of power. The power to regulate roads and the power to the real property taxation power. And their best argument is, well, those provisions wouldn't make sense if you accept our reading of the statute because we don't think those things relate to the operations or activities of the mining industry themselves. But they clearly do.
No, I think they're arguing that there are certain things that have to be, that are just local to you. I mean, your bridges, your roads, who knows what kind of trucks and things they're going to be bringing in and doing with this stuff. Maybe nothing. But you should have the right in your town to make sure that they're doing it and that they're not doing it, in the middle of the night or whatever. And with respect to the taxes, I took it to mean that when Mrs. Murphy decides she wants an oil well in the middle of her pasture, that maybe her taxes are going up.
No, and actually the property tax issue is very interesting. So there is a special provision of the Real Property Tax Law, Section 594, paren 2, which allows a municipality to impose a tax on an oil and gas, specifically on oil and gas well drilling, and it is based on the production from the well. That would otherwise be in complete contravention of real property taxation principles, under which taxation is based only on the value of the land, not the operations on the land. So it is, in that sense, it is clearly, that provision of the tax law is a regulation of the operations of the industry.
Is this all built on fear? Let me just get my thought. I mean, everybody's plus or minus on fracking. Now, people that have got gas underneath their land tend to like the idea of fracking. And, you always hear about Pennsylvania and things like that. Towns, you're not alone, say we don't want fracking in our backyard, and we just don't want it, and so we're going to zone it out. Is that what we're talking about here?
I would submit absolutely not. And here's what's interesting about that question is this has consistently been phrased as a ban on fracking, and that is not the case.
Well, what was the local purpose then in your municipality taking the action that they did?
It's a zoning purpose. This is a zoning law. So remember that under New York law.
Where's the zone in your town?
What does that mean?
Under New York law, if the town has a zoning ordinance and a use is not listed as a permitted use, it is a prohibited use.
Right. They want to prohibit this activity in the town.
Both before and after the enactment of the local law challenged here, oil and gas mining was not a permitted activity in the town. In fact, I submit the town didn't need this local law at all because The town of Middlefield has a very basic zoning code. It has a residential agricultural district. It has a residential hamlet district. Okay, you can have residential agricultural is just what it sounds like. You could have a house, a farm. Residential hamlet, you could have a house, a small store, a professional office space. Basically, in the town of Middlefield, you can farm, you could have a house, you could have a store. You cannot have any heavy industry of any description, whether it's steel mining, smelting, anything.
But the state could say that you can't do that, you have to allow oil and gas if they wanted to.
The state could if it wanted to. And let's take a look at those instances in which the state has. The state has done two things. The legislature has done two things when it has preempted local zoning law.
Well, if you didn't need this law, why did you pass it?
To clarify.
And you clarified it in saying what? That
heavy industry was not allowable use. Heavy industry includes oil and gas drilling. But let's look at those instances in which the legislature has expressly prohibited or preempted local zoning law. The legislature has done two things in those instances. It has expressly referred to zoning powers, and it has created an alternative siting mechanism.
Well, why is that any different from saying that the provisions shall supersede all and then two exceptions? How doesn't that accomplish the same thing?
Because you have to, in order for those two exceptions to even come into play, or for the preemption provision to come into play, it has to be a local law relating to the regulation of an industry. This Court has consistently held that zoning law is not a law relating to the industry, whether it's mining, whether it's alcohol, beverage.
So you're the same question I asked your adversary. There's something different about zoning than anything else that relates to the fundamental right of the municipality to be heard and to protect its own land?
And it is, this Court has consistently recognized that zoning is one of the, if not, in fact, the most fundamental power of a town.
This case is difficult, though, because it's pretty fundamental for local taxation as well. So the legislature addressed taxation, but they didn't address zoning.
And the reason for addressing taxation,
which is rather strange. They tend to go hand in hand.
Yes, but because of the unique nature of the taxation that applies only to the oil and gas industry. Let's look at the EnviroGas case, which is a case where the local ordinance was preempted because it imposed specific fees on the industry, and that's the right result. You can't impose a fee on the industry. But the legislature did create a tax provision, 594(2) of the real property tax law, that applies specifically to the oil and gas industry. And that's the reason for inclusion of that reservation in the statute. I agree. On its face, you would think, gee, a regular RPTL Article 7 proceeding or regular real property taxation
Does a plain language analysis allow us to dig as far as we're hearing here about
I would submit
all these other related statutes and the rest of what we're hearing in argument today?
I would submit the statute is plain on its face and doesn't preempt local zoning. And at best, what they've done here is...
Do we need Fru Run to come to that conclusion?
Fru Run certainly helps in reaching that conclusion. But I don't see any jurisprudential reason why the same plain language analysis that was followed in Fru Run wouldn't be applied here, whether that case exists or not.
What happens in practical terms once the state finishes its study and makes a recommendation? What's the consequence of that vis-a-vis what we're talking about today?
I submit none, because don't forget.
So what are they studying exactly? What are they studying?
Well, they're studying the technical aspects of hydrofracking.
And let's say they say hydrofracking is great, we should do it, or hydrofracking is terrible, we shouldn't. How does it affect you?
Well, if they say it doesn't, I suppose the issue is moot.
Say it says the opposite.
I would actually, I might take that back, because our zoning law applies to all oil and gas mining. It's not a permitted use in the town. okay? So the technology of how that happens is really not relevant to our zoning law.
So when you do that, I asked earlier about cell towers. If the federal government says you got to put in cell towers, you have to do it, right?
Well, if it explicitly says that, we're not making an argument that the legislature can't do it.
Wind
we're
power.
arguing that
They say you got to allow the wind power, the big.
Well, it's interesting. Wind power is a very interesting issue, and talk about statewide interests. I think I'd submit that the state has an interest in wind power. It's a statewide interest. It is left to the localities. Zoning laws apply to all to wind farms.
So but if they change their mind tomorrow, your position is the state could change its mind tomorrow.
And they can enact a different statute.
But at this point in time, you're arguing they have not specifically preempted.
Absolutely, they have not. And
if the study says hydrofracking is in, what happens next?
It doesn't affect the analysis, because unless the legislation changes.
Yeah, you're saying they could decide hydrofracking would be a very good way, a good source of energy for the state of New York, but they could at the same time say, but we'll leave it to the localities to decide whether or not they want it in their backyard.
And if you look...
Or they could say, it's now state policy, hydrofracking is open everywhere, no one can ban it.
And if you look at the DEC materials in the record, their proposal is basically to say the applicant has to show consistency.
When you say they left wind farms to the localities, how did they do that?
They didn't do anything. So whatever a town's local zoning law said, if you could only have certain things of a certain height, or you could only have certain property uses in a town. Many towns enacted their own wind farm local laws, but the legislature essentially didn't do anything.
There's no superseding provision at all?
There's no.
Nothing?
No. And I want to...
Could I ask you for a minute about the EnviroGas case, which you talked about a minute ago? You're saying that was rightly decided?
Yes, because in my view that was a regulation... regulation of the industry.
What Judge Green says here is that we're talking about subdivision Q of Section 4 of the zoning ordinance of the town. And it says that no oil or gas well shall be constructed in the town without prior payment of a bond and a permit fee.
Correct.
And you agree that's invalid?
Yes, because that is imposing...
Okay, but if they stopped after town and said no oil or gas well should be constructed in the town, that's valid?
Correct. Because that is a zoning power. It is not unique to the industry. It is a land use regulation. Let's use the example of petroleum bulk storage. There's a state petroleum bulk storage code. It says what you can and cannot do in the storage of petroleum. There's a couple of good Second Department cases that are right on point here, in which the one town enacts its own petroleum bulk storage code. The Second Department says, no, you can't do that. Another developer wants to build a warehouse in the town to store petroleum in a bulk manner, and says, oh, wait, the code preempts the zoning code here.
It sounds to me like you're saying you can do anything you want if you call it zoning.
You cannot. I would agree with you. You cannot tailor a law that specifically relates to the industry. You can have... You don't think your law specifically relates to the industry? No, it absolutely does not, because it does not...
They had a whole meeting to say, let's keep this industry out of this town.
No, the language of the zoning code doesn't allow oil and gas use, whether it's fracking or not, within the town. And that's to be contrasted from all those other instances in which the legislature has expressly preempted zoning power. It has always enacted a citing mechanism. I'd use the casino gaming legislation as the most recent example. So under the racing law, Section 1366, the statute explicitly says that once a casino or a gaming facility is located by the board, that shall preempt all local laws, including local zoning acts.
Thanks, Counsel. Thank you. Counsel Rebuttal.
Just very briefly, Your Honor, I just need to correct a couple of concepts. First of all, there's nothing really different about conventional drilling and high-volume hydraulic fracturing except the fact that they learned how to turn the drill bit horizontally.
So it didn't matter that the legislature may not have contemplated fracking when they passed
Well, in
it?
fact, Your Honor, fracking goes back, many, many years before the 1981 law.
So you think they contemplated fracking?
It was commonplace in New York. In fact, it's reflected in the 1992 treaty.
But isn't what's going on now an attempt to really understand the consequences of fracking? How can you say it's the same thing? Isn't that exactly the problem right now?
Well, Judge Rivera, with all due respect, what they used to do with the vertical well,
yes,
and then they'd hydraulically fracture it, they found out it's much more effective if you turn the drill bit and you go out a mile and you separate that into separate segments, because you get much more gas.
Yes, of course, but isn't the point then, isn't part of the debate and the controversy and the difficulty trying to figure out whether or not doing that has particular consequences that are not the same consequences of just drilling straight down?
That is part of the debate. And the debate has
So then they're not the same?
I would say they're fundamentally the same. I would say the impacts are less because you can drill 2 square miles.
Okay, but you may not win that argument, so they're not the same, correct?
I'll say they're not the same, but I don't think it matters for the preemption analysis.
Okay.
I'm just trying to
Fair
clarify a couple of concepts. As to surface,
So what in relation to what I asked your adversaries, so what happens if the state comes and says now hydrofracking is great?
If the state says hydrofracking is
How
great,
does that affect what we're dealing with today?
that would open up the state for operators to come back in and seek permits. Under the regime established
If we
by
agree with your adversaries, different towns may not have to have it, right?
well, we disagree. We think
No, but if we agreed with your adversaries,
And different
and
towns-
even if the study comes back and says it's great, if they don't, if there's not a law passed that says they can't ban it, then in as many hundred towns you're talking about, you wouldn't be allowed to have it there.
It's worse than that, Your Honor, because no prudent operator is going to go to a town, even if they allow it, when they're subject to a 3-2 municipal board vote that could change with one.
Is that what happens in Texas and Oklahoma that we've been hearing so much about from your adversary?
Your Honor, I'm not familiar. I am familiar with their ordinances, and I know that there are some municipalities that do regulate it through zoning, and the industry works very carefully with them to get through that process. But that's really not the issue.
Are you saying then that if we agree with your adversary, at least as of now, it makes the study almost irrelevant and it kills the hydrofracking in the state?
It has a very chilling effect, because it's very hard for operators to justify spending the hundreds of millions of dollars to come in and not have regulatory certainty.
But if the study comes back and says or suggests that the concerns are not really justified with respect to this particular type of drilling, certainly towns that have banning might reconsider the bans. Correct?
They might, but I think that begs the question of the issue before this Court, whether or not they have that authority in the first instance.
It's the uncertainty that would chill these operators from
That's
coming
correct,
in.
Judge Graffio, because you know, I've seen it in the landfill context where we had a resolution against, 3-2 in favor, and then it went against, and we litigated over vested rights. It's not a good situation for investment.
Doesn't that mean that you have to go to the state legislature and persuade them to be clear if they really want preemption to address the uncertainty, if they're concerned about this industry's robustness throughout the state?
That's correct, Your Honor. If we lose in this Court, our remedy is with the legislature, and as I said before,
Thanks,
I'm not willing to predict what will happen.
Counsel, rebuttal.
First, can I just address the subsurface nature of the oil and gas law in Middlefield? The law in Section 7 specifically talks about subsurface excavations and also includes gas pipes and gathering systems. You cannot gather gas from subsurface without pipelines and gathering systems. You can't float it away in balloons. So this law prohibits that subsurface activity as well, and thereby impacts the correlative rights of neighboring towns that might want to be able to do this without regard to municipal boundaries. The concepts that we've been talking about, and this is common throughout the country, to promote energy, to promote the use of domestic resources, this is now working. For the first time in my lifetime, we are closer to energy independence in this country than we have ever been. It's because of some of these opportunities.
But, you know, what sticks in my mind, when you talk about zoning, people decide how they want to live. And you've got, you know, very densely residential areas that say we don't want anything going on in our residential area. And as Mr. Henry pointed out, they got some rural ones, too. I would think that if fracking is great, I mean, I'd want to be in the town next to Dryden because you got no competition over there. You can drill all you want over here, and with the side drilling, you don't care what that town does, right?
Your Honor, I think we have to take a look at this case in terms of what we are going to reserve for the state. And it's whether you agree with fracking or not agree with fracking. It's not just fracking. It's many issues that might be before this court. Could be a casino in front of this court. Well, they can decide whether they're going to zone it out or not zone it out. All of those issues could come into play. The issue that we have is preserving this decision to the state when we have this sort of comprehensive statutory scheme. Yesterday.
Well, they agree that the state could preempt. Their position is they haven't. I mean, so the state legislature could do what you're asking for.
Of course. But the question before us is, what does this statute say and what will we be able to accomplish? Yesterday, President Obama and the EPA said that we are going to now have a mandate on states to reduce carbon emissions from power plants by 30%. I can tell you that if these decisions are not reversed, and we leave this to our 932 towns to make decisions about the energy policy in New York, we won't be able to do it.
Counsel, but you would acknowledge that there are sound public policy arguments both ways. On the one hand, you're saying, yes, we should have a comprehensive strategy to deal with such an important issue to our state, energy, which is obviously important. And on the other hand, municipalities believe, as I think Judge Pickett used the term, that we are here, we have to determine how we're going to live. We want to have some voice in how we live. So the two competing policy discussions that I agree with you, it comes down to what has the representatives of the people actually done. But I don't think either one or the other policy perspective necessarily prevails automatically. They're both good arguments. So it comes down to then, what did the representatives of the people actually do?
Your Honor.
Right? I mean, we all agree with that. You just disagree on what they did.
But we do agree, and we have to agree, that there are important state interests that sometimes the not in my backyard mentality will always oppose.
But all I'm saying is, all I'm saying to you is, there's a flip side of that argument, which is you don't bulldoze over the voice of the people in individual municipalities who want to be heard about how they live their lives. So I'm not taking either side, but I'm saying to you is, we get it. We get your policy arguments, and we get their policy arguments too. The question which we have to determine, what did the representatives of the people who ultimately have that power actually do? And we'll try and make that decision. So, thank you. Appreciate it.
Thank you, Your
Honor. Thank you all.
Thank you.